Good morning. Just a quick reminder that unless the court has put an order down saying otherwise, the cases are being live streamed through the AOC's YouTube channel, and the oral arguments will be placed on the AOC's YouTube channel afterwards. Call the first case, please.
Edward Jackson, Younger Family Trust, Family Irrevocable Trust et al.
We'll hear from the appellant.
Good morning, Your Honors. Tyler Chastain of the Knoxville Bar. I'm representing Robert Freeman individually and as former trustee of the Evelyn Ross Trust. I'd like to reserve 4 minutes, please, for my
That'll be
argument.
fine. 4 minutes.
Your Honors, in dealing with this case, there are a lot of issues here. As I joined the case, a summary judgment had already been granted due to prior counsel's failure to file a response. But that was not deemed a final judgment, and we went forward with the remainder of the case. In putting forth the issues that I've asked this court to review, I first want to note that my client, Mr. Freeman, is the only one that appealed. Ms. Ross is now deceased. Mike Ross did not appeal. And although the docket lists John Garrison as pro se, I've never seen that Mr. Garrison ever filed any petition to be part of this appeal as well, Your Honor. So I'm the only person appealing. The decision was rendered by Judge Ayler in the Knox County Circuit Court. He was hearing this case on a special appointment. It was filed in Chancery, so he was hearing this case by an appointment. Prior to my involvement, he got assigned. I am going to look at, Your Honors, because this is a case that was tried for over 4 days, had numerous motions, and was filed back in 2016, in my short amount of time to focus on several issues based upon the decision rendered by Judge Ayler, looking at the transcript of the final judgment that's located at the volume 28, pages 1 through 17. On bottom of 14 and page 15, the court, dealing with numerous issues, says the court, in reviewing the testimony of the witnesses in light of the credibility determinations that have been previously made, it's the opinion that all the defendants entered into a common scheme to defraud the plaintiffs, thereby coming into this court with clean hands. I'm focusing on that because one of our prime issues in this case is a statute of limitations issue under 28.3.105, the 3-year statute of limitations for claims for personal property. This case was originally filed on November 15, 2016, Your Honor. The transactions regarding the trust that are at issue here were completed with the trust actually being formed and the monies being paid on August 31, 2012. There's an issue raised as to whether it's the loans that were taken out by Mike Ross, who was the person who held the life insurance policy that was sold through this trust to the plaintiffs, was disclosed. The record in this case, as found by Judge Ayler, points out in this same opinion that he says on page 12, the first indication that she, meaning the Younger Trust and Tracy Youngers, had the policy, had any loans against it, and that there was interest due was in January of 2013 when she received the documentation. The trust made payments on the interest on these policy loans. That's what this case comes down to, is Mr. Freeman, rightly or wrongly, prepared documentations that transferred the life insurance policy with a face value of $1 million to the Younger Family Trust. My client, Mr. Freeman, was initially the trustee of what's called the Evelyn Ross Irrevocable Life Insurance Trust. He formed that trust, placed the policy in that trust, and thereafter, and that happened by the end of August 31, 2012. He resigned as of October 31, 2012.
But wasn't his resignation deemed invalid?
The court ruled that his resignation was invalid. The basis by which that, I'm not sure. He said that he was not allowed to resign. But the court said that if he didn't resign, then Mr. Garrison would not have resigned, and Mr. Garrison was appointed the trustee after that and served for a few years before Ms. Younger took over as the trustee of this trust. From reviewing the decision of the Judge Ayler, I'm not sure how you reconcile that with his decision as well on page 14 of his opinion, that the Evelyn Ross Irrevocable Trust contains the entirety of its agreement and cannot be altered or amended or changed by parole evidence. There's nothing that there was a successor trustee provision set forth in that trust, and I'm not certain, and Judge Ayler did not provide specific rationale into why he decided he could not resign. It's interesting, Judge Clement, is that my motion to have Mr. Freeman dismissed as the former trustee under the statutory provisions of 1005C was initially granted. He granted the motion saying that those claims against him as former trustee were not filed in time. Then counsel filed a motion to reconsider, and the judge then said he had no right to resign. That's kind of the gist of where we got to that issue, Your Honor. But you're correct.
Is the validity of the resignation critical to the statute of limitations, or is that a separate?
See, I don't believe that's critical, because the actions that were taken would have been completed by August 31, 2012, when the trust was formed and the monies were paid, and no later than the January 6, 2013 payment made by the trust at that point to Mr. Garrison, who was the trustee. And at that point, the payment was made for premium and interest, and this was reflected in the record, and the court found that as well, that they made payments of interest. And that's the primary issue, Your Honor, is that if they were paying interest, they were paying interest on something, and they were paying interest and had the obligation to examine what that was. And we believe at that point, even if you said there was a tolling of that, by the time they were making interest payments in January of 2013, they should have been on notice that the policy had something besides a premium on it. It had a loan of some $186,000 that Mr. Ross had borrowed prior to this transaction. So I believe, Your Honor, the trustee is one issue, but I don't believe that's the controlling issue, because the court found that there was a scheme to defraud but not disclosing this interest, Your Honor. As with everything with this case, one street leads to another, and that became the primary issue here, is that Ms. Younger said she never contacted Mr. Freeman because he was not the trustee by the time the interest payments were being made. And that was also testified to, and we've put that in the record. And as part of the record is what Judge Ayler relied upon, is that there's an Exhibit 48 where Ed Younger, who was the agent for the trust, Tracy Younger's father, and who made the decisions regarding this matter. Exhibit 48, he sent something in August 1, 2016, saying we've been making interest payments, and he puts the number in 2013, 2014. They were fully aware they were making interest payments, and that Exhibit 48 has the checks and all the notices that were sent, which clearly shows a premium and an interest due. So we believe that the trial court improperly found that there was a 6-year statute of limitations as opposed to the proper 3-year statute of limitations. This is a claim for property loss, if anything. This claim was initially filed as a sworn account. And at that point, but the court still ruled that it was a common scheme to defraud. So that claim should have been brought within 3 years at the latest of the notice when they made the payment of interest in January 6 of 2013 is our position. And the trial court erred in finding that this was a 6-year statute of limitations. The trial court relied upon...
I'm sorry, what was the basis for the trial court? Trial court stated its basis for applying the 6-year?
The trial court said that this is akin to a contractual action. And they said that under 28.3.109 that's what controlled was the contractual 6-year statute of limitations. I raised that issue once I became involved, but that decision was made prior to my actual involvement in the case, before I took over for prior counsel. But when reviewing the record and when I raised the issue again, that's what the court said. It was a 6-year statute of limitations. The court did not move away from the sworn account type situation, but still at the final decision talked about a scheme to defraud, which I believe falls under the 28.3.105 section, not the 28.3.109 section, Your Honor.
Was that addressed during the motion and hearing on the partial summary judgment? This statute of limitations, was that an issue with regard to that?
That issue was raised in a motion it was not part and parcel of the motion for summary judgment, but it was raised by counsel that was representing the parties at that time, and he denied that motion at that point. I raised it again along with Ms. Mears at a later point in the trial, which was actually in the first section of the trial that was tried in 19. We raised that issue again during the course of the trial, that this was still a 3-year statute of limitations, and that's what in part led to the amended complaint that had to be filed on December 12, 2019. The court directed an amended complaint to be filed, but we raised that issue again, Your Honor, and it was still, at that point, was still eventually denied the motion.
It's my understanding that with reference to the motion for partial summary judgment, it was granted in large part because the responses were not filed timely with reference to that motion. Is that correct?
As to Mr. Freeman, his prior counsel, Wayne Henry, filed no response, did not ask for an extension of time. He filed absolutely no response at all. So to say it was insufficient would be incorrect. It would be no response, Your Honor. And when I got involved, I filed a motion to set that motion aside, and that was not granted. And I saw it in an interlocutory appeal through the trial court, and that was not granted. But it was not from an inadequate response. It was from absolutely no response being filed. And he was present at the hearing as well and made no reference for asking for any additional time, Your Honor.
Thank you.
While there are numerous other issues here, Your Honor, I go back to the decision in the end. The damages themselves are tort damages, but then there's an award of attorney fees. For a common scheme to defraud, there are also attorney fees awarded, Your Honor. We believe that those would not be proper. If you just look at the damages of what's being awarded in this case and how this is mattered, this was simply a tort case. And if you look at paragraph 7 of the complaint, and that's the original complaint, it's a very extensive paragraph, but it specifically talks about the fact that this is a complaint because meaning Mr. Freeman, Mr. Garrison, and Mr. Ross did not advise that there was a loan taken out against the policy. And because of that, they suffered damages by having to make interest payments. We believe that if you go back to the basics of what this case is about as a matter of law, which your honors have the right to do in a standard review, to review that, whether that's a correct decision. It's not a question of fact here, it's a matter of law, that the application of the statute should start running as of at latest January 6, 2013, which would make the filing in November 15 of 2016 outside that 3-year statute of limitations. Based upon the decision, that's the basis for damages, Your Honor.
If I may question, the suit was on a sworn account, but you said the damages awarded were tort damages. Can you explain? Yes,
Your Honor. As a sworn account, Ms. Younger, on behalf of the trust, said that they had an account due and owing by my clients. Well, at the trial, this was not an account, Your Honor. There was no express agreement to pay like a credit card or a promissory note. What was tried was whether there were fraudulent misrepresentations, active fraud, or failure to disclose. There's not a contract in place that says I, Robert Freeman, or any of the defendants owe to the Younger Family Trust X dollars. And in my brief, we talked about the fact that I cited the Chumley case that talks about 24-5-107, which is the sworn account statute. It says Section 24-5-107 facilitates recovery of specific debts such as a credit card balance. And the case says the statute's not meant to provide an alternative theory of liability for traditional tort or contract actions. I'm out of time, I notice, Your Honor. So if I may not have answered your question. If I will, I'll finish before I sit down. Thank you.
You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
I'm David Lufkin of Knoxville. I was the original attorney who filed this complaint. And there's just a couple of points I want to make. We go through almost every question you've asked today is answered in our brief. But I think it's very important for this court to understand a few facts that I want to point out. First of all, this entire case relies on the granting of summary judgment for liability. And because of that, you have to look at the concise statement of facts that were presented to the court at that time. And that really creates, I call it in my brief, a novation away from the original arguments between the parties, because now we're talking about what the concise statement of material facts presented because under our rules, Rule 56, and court decisions, those become true, those concise statement of facts. And as Mr. Chastain has said, his predecessor failed to file a response to that motion. He appeared at the argument. The motion had been set by an agreed order, so there's no question about the date. And because they failed to file an answer or response to the motion for summary judgment, that is the basis of this case. My adversary counsel is concerned with statute of limitations issues, but I want to make one point very clear to your honors. This case arises out of an agreement to buy and sell a life insurance policy. The statute he's indicated, a 3-year statute, has a discovery clause in it which says upon discovery of the elements, that is when you're beginning. And the trust agreement that is the foundation of the contract between the parties in this case had 2 exhibits, Exhibit A and a second Exhibit A, that were never given to my clients at the time of the contract in 2012. And in fact, if you look at Exhibit 1, transcriptive evidence 30, page 15, the agreement exhibits were in a response filed by Martha Mears representing Mrs. Ross after the lawsuit was filed. First time we ever seen them. And so any statute of limitations argument is defeated by the fact that the elements that are important in this case were not even seen until after the discovery process, after the filing of the complaint. Because of the concise statement of facts and the novation of this case turning to those facts, if your honors will review those concise statement of material facts, it says there was an agreement between the parties prior to the Evelyn Ross Trust. And that agreement was to buy and sell an insurance policy. Then we have the Evelyn Ross Trust created by Mr. Freeman, the appellant, rather than just a clean sale. There's no question this case arises out of contract. I think the judge was correct in the 6-year statute. And the Evelyn Ross Trust is a contract. It is a contract between the grantor of the trust, Mrs. Ross, and Mr. Freeman, the original trustee. It is very important to realize that the court was looking at that trust agreement as a contract, but the motion for summary judgment and the concise statement of facts is what centers this case and determines Mr. Freeman's liability.
Slocum, let me ask you a couple of questions here about the trial judges, some of the language that you used in granting the summary judgment.
Yes.
We talked about the fact that, nothing was filed in opposition to the motion summary judgment, no response to the statement of undisputed fact. But then the trial court said, if this response is not filed, the moving party is entitled to a judgment as a matter of law.
Correct.
Is that an accurate statement?
Yes. And
what if the material facts, statement of undisputed material facts, filed with the motion for summary judgment?
correct, the concise statement.
Didn't show a basis for liability here. I'm not saying they didn't here.
Right.
But I'm just saying, does the trial judge still have to look and say, all right, there's no response to these material facts, these undisputed material facts listed that accompany the motion for summary judgment, and taking those as admitted, then summary judgment is appropriate? Or does it just say, it doesn't matter what they are? Maybe all they said was December 31st is the last day of the year, and something like this, but you still get summary judgment if there's no response.
In this case, the concise statement of facts almost exactly verbatim mirror the allegations of the complaint. And the allegations of the complaint make out all the arguments that you're talking about that would have given the court the right to grant a summary judgment for liability. And by the way, that's been held by the Court of Appeals decision in Brecker versus Virginia Story in just January of this year, that if that is the case and there is no response filed, then as a matter of law, those facts become true.
But you still have to look at those facts to see if the plaintiff would be entitled to summary judgment.
Correct.
Okay.
And if you look at our brief, we go through and cite all the elements and all the damages that were cited not only in the complaint, but also in the statement of concise facts that the judge had in front of it at the time Mr. Freeman failed to file the response.
Mr. Lufkin, do you agree with Mr. Chastain's statement that the damages that were awarded were tort damages?
No, absolutely not.
Okay.
The damages in this case are contractual damages, as cited in the complaint and in the concise statement of material facts, arising out of the fraud that the defendants used by not supplying Exhibit A. Okay? Exhibit A, attached to the trust agreement, clearly defines the value of the policy not being $1 million, but $859,000. And that was a case that existed since Mr. Ross chose not to renew a premium amount back in 2003. On top of that, there was $186,000 in loans against the policy that were not disclosed. Those are documented in Exhibit A that was attached to the trust agreement, and they're signed by the appellant and Mrs. Ross. There's two versions of it, but they were supplied in discovery. We had never seen them until this case had been filed. The other thing I wanted to point out, Your Honor, is that the trust agreement itself, drafted by the appellant, maintains that the substitute trustee can be appointed by the primary beneficiary, which was my client, the Younger Family Trust. My client, the Younger Family Trust, was indicated in the agreement Mr. Freeman drew up. And so they had the right to appoint and did appoint Tracy Younger as the substitute trustee. That trust agreement drawn by the appellant also has a paragraph as to attorney fees cost. If a disagreement occurs, the prevailing party gets the attorney fees and cost, and that is what Judge Younger used to evaluate the attorney fee claim in this case.
Excuse me, you said Judge Younger. Did you mean Judge Ayler?
Ayler, yes.
Thank you.
Yes. I know I'm about almost out of time, but I think if you'll review the motion for summary judgment and the concise statement of facts and the mirror in those documents as to the complaint, you will see that every element that was necessary for Judge Ayler to determine liability on a contractual basis is all right there. Any questions?
I hear none. Thank you. Hear from the appellant rebuttal.
I wanted to follow up and just finish my statement that I was answering for Judge Clement on the issue of damages. When you look at the award of damages in this case, they were also made jointly and severally. Our statute 2911-107 says joint and several liability. A, if multiple defendants are found liable in civil action governed by comparative fault, a defendant shall only be severally liable for the percentage of damages for which fault is attributed to such defendant. By the trier of fact, no defendant shall be held jointly liable for any damages. Once again, the damages themselves, as I pointed out, there's monies that were actually taken by Mr. Garrison that are part of these overall damages. The court used tort principles, tort concepts, and found fraud. That's why we believe, Your Honor, that this is a tort case covered by the 3-year statute of limitations. I just did not get to finish that up. The other thing that I want to point out, Your Honor, is that the record is clear, and Ms. Younger testified she received documentation related to this loan purchasing of this policy prior to writing a check for $205,000 to Mr. Garrison for distribution. They sent it to a CPA, didn't have any questions. They didn't ask for any other documents, didn't ask for any other times for review. That is not disputed. That was her own testimony. It says, we elected to do that. My father told me to pay the money, and we were good to go, and that's what happened. To say that they did not have an opportunity, they received these documents prior to August 31, 2012. They had no questions. They decided to pay it, and if there was other issues, they were not life insurance related or policy related. They had the right to go get it. They had the right to look at it and elected not to do that, Your Honor. I hate that Mr. Freeman's in this situation. When filing a response to a motion for summary judgment would have been something that I would have done, but I didn't have that opportunity. But also know that that was not a final judgment, and still the court we conducted over 4 days worth of trial on all the issues and raised the same legal issues again at both the November and the 2019 trial and the statute of limitations, and they raised it again once the amended complaint was filed. We believe those issues are proper for this court's determination, and we ask the court to reverse the judgment as to Mr. Freeman. Thank you.
Thank you. The court thanks counsel for both sides. We appreciate your arguments and your briefs in this matter.
Thank you, Your Honor.
Y'all have a good day.